can we begin?
Hi, this is Josh Blackman. I am the president of the Harlan Institute, and I am thrilled to present the 2020 Harlan Institute ConSource Virtual Supreme Court competition. Today we are arguing the case of Espinoza versus Montana Department of Revenue. We have two teams from Creekview High School in Texas. We have Aileen May and Daniel Sawyers, and Makaylia Askew, a returning competitor, and Jacqueline Aliman, all from Creekview. The petitioners will begin with 15 minutes. Counselor, you can begin whenever you're ready.
May it please the court, my name is Daniel Sawyers, and along with my co-counsel, Aileen Mai, we will be representing the petitioners, Andrew Espinoza, Jerry Ellen, and Jamie Sheffer in today's case. The court benefits from a brief recitation of the facts.
Please.
2015, the Tax Credit for Qualified Education Contributions Act was enacted by the Montana legislature. Under this act, individuals can donate money and receive up to $150 tax credit. The organizations that receive this money can then use these funds to provide scholarships for qualified families and children. Big Sky, one of these organizations, planned to use this money for religious and non-religious schools. But in order to comply with the Montana Constitution, the Department of Revenue issued Rule 1. In accordance with this, the Big Sky for to give scholarships to students.
Okay.
In our time before the court, you'll be demonstrating how, in the absence of substantial state interest, this court is required to rule that the leveling down of the scholarship program is unconstitutional under Church of Latinity Avenue, and that Section 1, as applied to the Montana Constitution, discriminates against religious beliefs, conduct, and status, as well as imposes special disabilities on the basis of religious status in contravention to Trinity Lutheran.
When addressing our first point, the leveling down of the Montana tax credit program is in violation of Church of Latiny's values, because in that case, it states that under the free exercise clause, a law that burdens religious practice cannot be justified by compelling government interest if it is neutral and of general applicability. Employment Division Department versus Smith.
However, where such a law is not neutral or of general application, it must undergo the most rigorous of scrutiny. It must be justified by compelling government interest and must be narrowly tailored to advance that interest. Neutrality and general applicability are interrelated, and failure to satisfy one requirement is likely an indication that the other has also not been satisfied.
Okay, Counselor, let me interrupt you if I can for a minute. You've talked a lot about the free exercise clause. How does the Establishment Clause play into this case?
I'm sorry, can you repeat that, Your Honor?
I'm sorry if you can't hear me. Your connection is breaking up a little bit as well. You've talked a lot about the free exercise clause. How does the Establishment Clause play into this case?
Well, Your Honor, I believe that the Establishment Clause, it can be a reflection of the state's motivation to not, their desire to not put forth any specific religious denomination or sector, and in order to stay without violating the Establishment Clause. However, in this case, it could be reasonably argued that keeping the tax credit program up does not violate the Establishment Clause, and there's sort of a play within the joints of the Establishment Clause and the Free Exercise Clause, to where the state in this case is not necessarily violating the Establishment Clause if they were to keep the tax credit program up, but if they were to level down in this case, then they would be violating the Free Exercise Clause.
Well, Counselor, let's talk about Montana law, and tell me about Article 10 of the Montana Constitution.
Well, Your Honor, Article 10 in this case is it states that the legislators of Montana cannot directly or indirectly give any aid to any church, school, academy, or anything that is related to a religious organization or sector. Mm-hmm. And as petitioners, it is our contention that this is a violation facially and as applied in this case.
So you think that Article 10 of the Montana Constitution is unconstitutional on its face? Is that your position?
Yes, Your Honor, because, well, it can, in this case, it's definitely unconstitutional as applied. However, we do not necessarily contend that it's in all cases it's unconstitutional facially. However, all that's required in this case is for the application of Article 10 to be unconstitutional as applied.
Well, Counselor, what's the best case you have to say that that Article 10 is unconstitutional? What's your leading case?
Trinity Lutheran, Your Honor.
Okay, so explain your argument. Why does Trinity Lutheran require us to declare Article 10 of the Montana Constitution unconstitutional?
Well, Your Honor, a lot of the facts in this case are similar to Trinity Lutheran, and the holding in Trinity Lutheran holds three main prongs that we'd like to bring in our argument. The first being that a law may not discriminate against some or our religious beliefs. The second being a law may not regulate or outlaw religious conduct because it is religiously motivated. And third, it may not impose special disabilities on the basis of religious status. And with the facts being similar and Trinity Lutheran in this case, we believe that the holding in Trinity Lutheran should be applied.
Okay, so let's talk about maybe I'll ask a question for your co-counselor, Aileen. In Trinity Lutheran, what was the religious school asking money for? What did they want money for in Trinity Lutheran, Aileen?
The religious school was asking money for tire scraps for their program.
Okay, and they wanted these tire scraps so kids wouldn't, hurt themselves in the playground, right?
Mm-hmm.
Public safety. What is the money being used for in this case? In other words, when the Stillwater Christian Academy gets this money, what is the money being spent on?
The money is being spent on the education of the students on receiving it. Even though the usage for the aid is different, one being a playground and one being education, they both are common in the fact that they help the people who are getting it. Because the playground is to help the children who play on that playground.
So, Aileen, let me ask you a question, please. Can this money be used in Montana to purchase Bibles for the students?
No.
Why not?
Because in Rule 1, it says that the money is given to help with religious education, but it can't necessarily be given to buy Bibles because the money or the Rule 1 is for non-religious.
Yeah, but once the school has the money, they can just shift it around and use it to purchase Bibles, right? What stops them from doing so? Is the state going to supervise how they spend the money?
The state isn't necessarily monitoring how they use the money, but the state should take some extra precautions to make sure that religion and religious schools are separated and that they just don't use it to buy Bibles.
Yeah, but if I look at the Montana, the Montana scholarship program, it doesn't have any supervision. It's, they get the money and they can do whatever they want with it.
Yes, they can get the money and do whatever they want with it, but we have to have full faith in the fact that the schools will use them on education rather than using it to buy Bibles or rosaries to help further their religion.
All right. Well, counsel, let me ask a different question. Maybe for Daniel. Let's talk about Locke v. Davey, right? How does Locke v. Davey affect the outcome of this case?
Well, Your Honor, I believe Locke v. Davey is generally an exception to cases like these, and Locke v. Davey wouldn't necessarily be applicable here because in Locke v. Davey, I believe that the petitioner in that case was specifically trying to acquire state funds to go forth in a seminary school that is specifically and only tailored towards learning religion, and that's what the state money is only going towards religion. However, what differentiates this case from Locke v. Davey is that naturally states have a duty to educate up to a high school education, and in this case, the money is still being used to educate a high school education because the tax credit program is going towards recognized schools that do a state interest and carry forth a state burden by educating youth, high school age or any other, or middle school age children in this case. So the differentiation in this case is the fact that the state money is going towards a state burden, whereas in Locke v. Davey, it was strictly going towards seminary school, which the state has no burden at all in any form.
Well, let me ask you this question, counselor. why can't Montana decide to take extra precautions to prevent violating the Establishment Clause? In other words, why is it so problematic they want to maybe make the separation between church and state a little bit greater? They want to have a greater separation. Why is that problematic?
Well, Your Honor, it is not necessarily to our contention that if the state originally came out with the tax credit program and it was just specifically tailored to public schools, I don't necessarily believe that that would be a violation in itself. However, the state in later, like in having the general program available and then taking this step after the fact the rules were made to impose a special disability and specifically exclude secular schools from taking part, we believe that's where the constitutional violation takes place. And also, the last paragraph in Trinity Lutheran, the court states that you can't deny a generally available public benefit to an entity that's otherwise qualified based solely on its religious character or nature, which is exactly applicable in this case.
All right. Well, maybe a question for Miss May. How do you think James Madison's memorial and remonstrance plays into this analysis?
Can you rephrase your question, please?
Sure. Are you familiar with James Madison's memorial and remonstrance?
Yes.
Okay. How does Madison's memorial and remonstrance affect our inquiry here?
Well, Your Honor, in James Madison's remonstrance, he was doing it in opposition to a bill that establishes a provision for teachers or ministers for the Christian religion. And in his remonstrance, James Madison asserted that religion cannot be forced onto the people. So essentially what he is trying to say is that people have to be able to freely believe or not believe in a certain religion. And that plays into this fight, because even though the Christian school doesn't solely teach religion, most of the parents choose it because it helps back up religion or Christian values that they teach at home.
Okay, very good. All right, counsel, you may proceed with your argument.
There is no question that Article 10, Section 6 of the Montana Constitution forces a burden upon religion, especially considering the amount of potential funding that has been lost among schools, such as Stillwater Christian School in this case, simply because they are partly associated with the religious sector. But it could be argued that there was no burden if funding only went to public schools. The scholarship itself was designed to be generally applicable to qualified education providers. However, the later issuance of Rule 1 directly placed a burden on Stillwater by specifically excluding it from a widely available government program.
When considering that the burden was directed at religion itself, under churches with community values must undergo the most rigorous of scrutiny and must be justified by compelling government interest and must be narrowly tailored to advance that interest. But because it's not of general applicability and neutrality, the standard of compelling government interest is simply not met within this case. And Article 10, Section 6 is not narrowly tailored in any sense, as it uses general terms to discriminate against any sectarian purpose. There is no substantial government interest in directly targeting religion in this case, as the grant program is religiously neutral. With the grant being religiously neutral and widely available, then there can be no possible substantial governmental interest, as the government is, in cases like these, motivated by states' desire to not put forth any religious cause through government action. Especially under the most rigorous scrutiny where compelling government interest is required, this court should come to the conclusion that the government action in this case is in violation of Church of Lukumi values.
Well, Counselor, in Church of Lukumi, there was evidence that the Florida government was deliberately targeting the sanctuary of faith. Is there any evidence here that there was any sort of hostility towards religion of any sort? Any sort of animus towards religion? Is there any evidence that you can cite?
Even though it doesn't directly state that, the government is coming for these religions, we can tell that as applied, the government is coming for these religious schools and not giving aid and promoting non-religious schools over religious schools. So even though it's not on its face that the government is chasing after religious groups, as we look at it as applied, it shows that the government is discriminating against religious schools from non-religious schools.
Okay, you have about a minute left. If you want to move towards your conclusion, please.
Honor, in this case, we have proven that Amendment 1 of the Montana Constitution is discriminatory because there's no substantial state interest in enforcing Article 10, Section 6 of the Montana Constitution, which under Church of Routine validly would make the discrimination of religious schools, in this case, unsanctioned, as well as fail to see categories set forth in Trinity Lutheran.
It is for these reasons that we pray this court will in favor of the petitioner, Kendra Espinoza, and overturn the ruling of the court.
Okay, perfect. Right on time. Thank you, Counselor. All right, we'll now hear from the respondents, Makaylia and Jacqueline. You can begin whenever you're ready.
Hey, please support. My name is Jacqueline Aliman,
My name is Makaylia Askew.
and we represent the respondent, the Montana Department of Revenue, in today's case.
We are arguing that the free exercise clause of the First Amendment does not prohibit states from withholding funding from student aid because, one, past precedent upholds the constitutionality of withholding funding from religious schools. Two, the history of the free exercise clause shows that there is no violation of the petitioner's freedom of religion. And three, the no aid clause is constitutional.
First, when looking at past precedent and constitutions, the refusal of funding religious schools is constitutional. Article 5, Section 11.5 of Montana's Constitution states that the multiple provisions within the 1972 Constitution reflect the overarching principle that public funds should be spent only on public programs within the control of the state. For example, the Constitution's legislative article prohibits any appropriation or benevolent purposes to any private individual, private association, or private corporation not under the control of the state.
Employment Department Division of Human Resources of Oregon v. Smith held that when addressing the constitutional protections for the free exercise of religion, we can establish the general proposition of a law that is neutral and of general applicability need not be justified by a compelling governmental interest, even if the state has the incidental effect of burdening a particular religious practice. Jurists ranging from Justice Brenneman to Justice Sutton, along with constitutional scholars throughout the decades, have recognized the vital importance of state constitutions in protecting individual liberties. They even recognize fundamental rights not explicit in the federal Constitution.
So, Counsel, if I could just interrupt you for a minute, I appreciate that there's a lot of different perspectives on the on how we should interpret state constitutions, but your friends on the other side have said that Article 10 is unconstitutional in its face, and that Article 10 is inconsistent with Trinity Lutheran. How do you respond to that argument?
Absolutely, we veteran the outcome of today's case because, unlike in Trinity Lutheran, where the court was barred from receiving a generally available benefit, it was penalized for being a church in violation of the free exercise clause. Today's case, because the Montana Supreme Court invalidated the statute as both to religious and non-religious schools, is ensured that there was no coercion or penalties, and therefore there was no Article 10 of the Montana Constitution is constitutional.
Okay. Well, now let me ask one more question. Trinity Lutheran said that Missouri violated the free exercise clause because they discriminated against religious status, right? If you were non-religious, you got the funding, and if you were religious, you didn't. Right? In other words, the sole factor why the church was denied funding was because they were religious. Isn't that exactly what the Blaine Amendment does? That if you're religious, you don't get funding, and if you're non-religious, you get funding? I don't see how you reconcile the Blaine Amendment, Article 10, with Trinity Lutheran.
Your Honor, would you mind rephrasing your question? Your Honor, would you mind rephrasing your question?
Sure. How do you reconcile Trinity Lutheran with the Blaine Amendment? They seem to be in tension.
Sorry, what was that last part, Your Honor?
They seem to be in tension, the Blaine Amendment and Trinity Lutheran.
Well, Your Honor, the Blaine Amendment of the Constitution, the Blaine Amendment of Montana's Constitution was simply reflecting the state's interest in respecting the distinctive nature of religious education, therefore avoiding interference in religious schools, and also protecting its state funding resources for public education. So the Blaine Amendment ensures that the public accountability for education and therefore avoids entanglement with religion.
Okay. Well, let me ask one more question. Is the Blaine Amendment actually a correct statement of Establishment Clause? In other words, could Montana provide this funding consistent with the Establishment Clause? Would that be possible?
No, Your Honor, because the Blaine Amendment, because of the No Aid Clause, which was enacted in 1835, states that governmental entities are not allowed to provide funding to religious sanctions in order to protect the religion. It prevents governments from overstepping their boundaries and controlling what religious institutions are allowed to do.
Oh, let me ask my question. Let me ask my question a little bit differently. Let's say Montana didn't have the Blaine Amendment, right? Let's say they never enacted the Blaine Amendment. Could this policy be valid? In other words, would the scholarship program violate the federal Establishment Clause, assuming there was no Blaine Amendment in Montana?
Your Honor, would you mind restating your question?
I know. I'm sorry. The connection's not ideal. I know you're doing the best you can. Let me ask the question simpler. Let's say Montana has no Blaine Amendment, right? Let's say they have no Blaine Amendment. Would the scholarship program be constitutional under the federal Constitution?
Yes, Your Honor.
Okay, so if the scholarship program is constitutional under the federal Constitution, would you agree that Montana is going above and beyond what the Establishment Clause requires?
Your Honor, yes, in the sense that they are going above and beyond and making sure that their government does not overstep their boundaries when it comes to religious institutions and sanctions.
Okay. All right, you may proceed with your argument. I realize that we're having some technical difficulties, which makes it hard for you to hear, but you may proceed with your argument. We'll ask a question in a minute. You may go on.
Refusing states this latitude on borderline church-state issues would be playing in the joint between the religion clauses this court has wisely and repeatedly recognized in Locke v. Dayton. Montana's Constitution reflects the state's interest in respecting the distinctive nature of religious education and wanting interference with religious schools, and it protects against government involvement in religious institutions.
In Brown v. Board of Education, the federal constitution makes no reference to schools or education, leaving to the states the establishment of a public education system, its financing, and the contours of the right to quality public education. As a result, nothing in the federal constitution undermines Montana's sovereign prerogative exercised by the 1972 Constitution to deploy public funds to guarantee equal quality public education and to build a church-state wall for education in that acknowledged space between the free exercise and establishment clauses. Our federal system was designed
Jacqueline,
to
if I can ask you a question, what happens? In other words, what happens when the wall between separation of church and state gets too high? Can that ever violate the free exercise clause?
I'm sorry, can you repeat that?
When the wall separation between church and state gets too high, can that wall itself violate the free exercise clause?
No, it cannot violate the free exercise clause, sir.
What if What if the state passed law that said no tax credits, no tax exempt status for religious institutions, right? If you are a non-religious charity, you can get a tax exempt status, but if you're a religious charity, you can't be exempt. Would that be problematic?
Well, in that sense, you said, I'm sorry, can you repeat it one more time? I'm very sorry. I could barely
I know.
understand.
I'm sorry. You're doing the best you can. If the state prohibited tax exempt status for houses of worship, right?
Yes.
Would that be problematic?
In that sense, yes, it would be problematic
Why?
because it means that it is going to charities, which is different from providing education to children.
Okay. All right. You may proceed with your argument. You may proceed.
Second, the history of the Creation Clause upholds that there are no violations. The attack on Montana's No Aid Clause provisions represents a long tradition of non-interference with religion and undermines the complementary nature of religious liberty provisions in national and state policies. The complementary nature of religious liberty provisions in, the Free Exercise Clause of the First Amendment states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Under the petitioner's position, any provision that bars the funding of religious schools violates the Free Exercise Clause. However, 38 states have made such provisions, and they even date back to 1835, and rarely has any court overturned provisions that have so long standing and widely spread.
Zora v. Clausen held that there cannot be the slightest doubt that the First Amendment reflects the philosophy that church and state should be separated, and that as far as interference with the free exercise of religion and the establishment of religion are concerned, the separation must be complete and unequivocal. The First Amendment within the scope of coverage permits no exceptions. However, the First Amendment does not say that in every and all respects, there shall be a separation of church and state. James Madison, in his memorial and remonstrance against religious assessments, warned that a prudent jealousy for religion freedoms required that they never become entangled in precedents.
He strongly believes that convictions are reflected in the first clauses of the First Amendment of the Bill of Rights. As one delegate to the Oregon Constitutional Convention stated his understanding of the principle, nor did he believe that the government had any right to take public money contributed by the people of all creeds and faiths to pay for religious teachings. It was a violent stretch of power and an unauthorized one. A man in this country has a right to be a Methodist, Baptist, Roman Catholic, or whatever he chooses, but no government has the moral right to tax all of these creeds and classes and inculcate directly or indirectly the tenets of any of them.
Right, but maybe, Counselor, if I could ask a question, hopefully you can hear me. With the memorial and remonstrance, Madison was complaining about a program in which people were required to donate. In Montana, there's a choice, right? No one's being required to donate. It's being run by private organizations. Isn't that one way to distinguish the situation in Virginia from the situation in Montana?
Excuse me, Anna, would you mind restating the last part of your question?
In the Virginia law, people are required to donate. In Montana, it's optional. It's a choice. Isn't there a difference between the two programs?
Yes, Your Honor. However, when, in the sense that one state is required and one state has the option to with the no aid, with this, the option to could eventually disappear, and they could become required to doing so. So by looking at James Madison Memorial, it would be a kind of stepping stone to make sure that whether or not they are able to choose or required to, to donate money to religious sanctions, it would still to
Okay. And Council, you have about 30 seconds left. You can move to your conclusion.
the free exercise clause of the First Amendment does not prohibit states from withholding funding from student aid programs because based on past precedent, the refusal to fund religious sanctions is constitutional. And an Employment Department Division of Human Resources of Oregon v. Smith held that the general proposition of a law that is neutral and of general applicability need not be justified by a compelling governmental interest, even if the state has the incidental effect of burdening a particular religious practice.
And in James Madison's memorial, he
Okay.
stated
And
that
you just about out of time, Counselor. So I'll stop you right there. Okay, very good. Thank you so much. I'll put you to a mute. And petitioners, you have 5 minutes for rebuttal.
My name is Aliman, and I'll be addressing the rebuttal on today's case. Contrary to what opposing counsel is holding, the simple leveling down of the program as a whole does not remedy the discrimination in the case, as we cannot let the remedy of leveling down shield the discriminatory action, especially since the motivation for leveling down is motivated by the petitioners for sending children to a non-secular school. Additionally, when looking at whether or not there was a violation of the free exercise clause, we can look to Trinity Lutheran versus Comer, where the court reiterated three fundamental beliefs of which free exercise church students. Not one, the law may not discriminate against some or all religious beliefs. Two, nor may the law regulate or outlaw conduct because it is religiously motivated. And three, law does not impose special disability on the basis of religious status. Only one of these principles needs to be violated in order for it to be a violation of the free exercise clause. When addressing the first principle is violated because Rule 1 provided that the scholarship could not be provided to students at a church, school, academy, seminary, college, university, or any other sectarian institutions owned or controlled in part or in whole by any religious institution. This violates the first fundamental principle because it discriminates against all religious beliefs because they are not able to give and receive scholarships under Rule 1 of the Montana Constitution. Article 1 of the Montana Constitution says that these scholarships or grants can only be given to secular or non-religious institutions, which leaves these religious institutions in the dark as they are unable to be given.
Well, Counselor, let me go back to a question I asked before. Right? What happens if the schools start purchasing Bibles with this money? What is the state supposed to do at that point?
Your Honor, if the states find out that these schools are using this scholarship for not educational purpose, but rather for buying Bibles and other religious artifacts, the state can come in and intervene and say you can't have these scholarships or this.
Right, but doesn't that create the risk of what might be called entanglement? Right, that the state will become entangled with religion. Isn't there a risk there?
Yes, Your Honor, there is a risk. And if you want to prevent entanglement, then there should be a more clear outline in the Montana Constitution that says, oh, you can use these scholarships for this, and this is what happens if you're using it to buy Bibles or like religious statues.
Right, but like what you're proposing is that the state can supervise how the schools spend their money. Wouldn't a better solution just be don't give them money at all? Don't have that sort of possible leverage, that possible entanglement concerns?
Not necessarily, because by not giving or encouraging the scholarships to these religious institutions, it could also create some doubt in people's minds as to whether or not they're allowed to practice this religion, because some couples or parents are not even a choice to send their children to religious school. Because in the Vatican Council, it says that any Catholic couple or family must send their child to a Catholic schooling program throughout their life, and many Orthodox Jews believe the same thing. So, by not giving these religious institutions this aid, it creates the notion that, oh, you're not allowed to participate in your religion.
Okay, Council, you have about a minute left. You can go to your conclusion.
It is for these reasons that this court could court rulings for the petitioner and overturn the ruling of the lower court. Thank you.
Okay, thank you. All right, petitioners, thank you for your time. Respondents, you have 5 minutes rebuttal. You can begin whenever you're ready.
May it please the court, my name is Makaylia Askew, and I'll be addressing one point before the court today. 1, that Trinity Lutheran should not be used to decide the outcome of today's case. As stated before, Your Honor, Trinity should actually not be the case used to determine the outcome of today's case, because unlike in Trinity, where the church was barred from receiving a generally available benefit, it was penalized for being a church in violation of the free exercise clause. Because the Montana Supreme Court in today's case invalidated the statute to religious and non-religious schools, it is ensured that there will be no indirect coercion or penalties, and therefore no prohibition, nor any discrimination towards religious schools. And even if the school were to use Trinity Lutheran's 3-pronged test in determining whether there was discrimination against religion, all 3 prongs have passed, because there was a governmental interest in wanting to protect the citizens' freedom to believe and practice what they wanted to without the government having control over what they wanted.
So, Counselor, let me ask you a question. You know, we've said in Trinity Lutheran that the tire scraps were to help kids, you know, not hurt themselves. But isn't there another purpose, right? When the church has this beautiful playground that's nice and safe, it may attract people to go to the church and may bring more people into the religious world. Aren't the tire scraps more than just safety measures? Don't they actually help the church promote their religion? I mean, you might be reading Trinity Lutheran too narrowly.
Well, Your Honor, the issue in Trinity Lutheran was not whether or not they would be able to have more people come to their church. It was the fact that the person who was over the tire scraps was making them choose between being able to practice their religion or being able to replace the ground on their playground. In today's case, there is none such, because of the fact that Montana decided to rid themselves of this to both religious schools and non-religious schools, so that the citizens don't have to choose between their religion and having an education.
Okay, may I proceed, Counselor?
It is for these reasons we pray that the court will in favor of the respondents, the Montana Department of Revenue, and uphold the lower court ruling.
Okay, thank you so much, Counselor. Let me come back on. Hope you all can hear me. I'm really grateful that you were able to participate under these difficult circumstances. What you're doing is not easy. It's even harder because you're stuck in your houses on your iPhones doing this with lousy bandwidth. And I think my signal might have dropped a few times, so I apologize. But you all did very well. I asked you lots of really difficult questions. I made you draw lines, and once I drew that line, I pushed you over the line, see how far you would go. And I think for the most part, you all stuck to your guns. You should be very, very proud of yourselves. I'm proud, at least. Sebastian, is there anything that you'd like to add?
Yeah, this is obviously a very contentious and intricate case. So that's sort of the reason that we chose it. It's very interesting, and there's really no clear answer to a lot of these questions. So definitely impressive that you all were able to just stick in there under Josh's fire, and were so successful at it. I know that I certainly could not have done nearly as well when I was your age. So well done.
Okay, very good. Does anyone have any questions for me or Sebastian? We'd be happy to answer them about the case or about anything in general. Now you'll want to sign off. Okay, very good. Makaylia, is there a question?
I was just wondering, is Creekview the last school that you're going to have rounds for?
Yes, I have a couple more of your teams today. We've had, I think, 20-something teams total. We're probably going to do another round, a quarterfinals. These are the semifinals. I think we're going to have the top 8 teams advance to a quarterfinal, and then we'll have the top 2 teams advance to the championship round. Unfortunately, we're not flying to Washington, D.C. this year. Not going to happen because we can't leave our houses. But I think we'll do at least one more round, and we'll definitely be in touch with your teacher soon, okay? And I'll put this video on YouTube a little bit later today. All right. I will draw this to a close. Thank you all so much. I wish you the best of luck. If you have any questions, you're welcome to email me or Sebastian. Thank you.